Welcome to the Michigan Supreme Court Historical Society's Oral History Project. My name is Mark Cooney and I'm in Ann Arbor. It is October 24th, 2019, and I am delighted to be joined today by the 100th Justice of the Michigan Supreme Court, Justice Clifford Taylor. Welcome.
Thank you, Mark.
Welcome to your own home, I should say. Your new lovely home here. So good to see you again. It's been a while.
Nice to see you again.
Yeah. Well, I was sworn into practice in 1992, which was right at the time that you became a Michigan Court of Appeals judge. And so I think of you as an appellate judge and justice, but I suppose there was a version of you before those days. So I'd like to go back into your history, even back to childhood, and I think that the people would be interested in hearing how you became the Chief Justice of the Michigan Supreme Court. So where was home as a child?
Well, I was born in Ohio, and I left there when I was 18 months old. I didn't like the football, and so we came to Flint. My dad was a Presbyterian minister, and then later became a public school teacher. But he came up here to serve a church in Flint, and we lived there, and we lived in Flint until I graduated from high school. And I went to Flint Central High School, which has had some rocky times and I think is now closed, but at the time was a really quite remarkable school. They still practiced tracking in those days. So it was a large high school, but they had people who they thought had some opportunities to go farther. They sort of separated them out, and so I was in classes with very talented people and very fine teachers. So I got a fine education in Flint. And after high school, I went to the University of Michigan for 4 years, graduating in 1964. I took my degree in history with a minor in economics, and I really enjoyed Michigan a great deal. And then I went off to law school at George Washington in Washington, D.C., which was a very different experience. It was a big city and so forth. And I enjoyed law school. And the most significant thing to happen to me in law school was that I met my wife. And so we got married a while after we were in the same class in law school. And then I went into the Navy. The year was '67, and there was a lot of pressure on people to do military service because there was still a draft. And I became an officer in the Navy and really enjoyed it. I was in the Navy I had a 4-year commitment, but I think I was out in about 3.5. My first tour of duty was on a destroyer, and it was in the Atlantic Ocean, not in the Pacific. Of course, the war was in the Pacific, but in any event, I enjoyed serving on the destroyer. It was really quite an interesting job. And then I served on an admiral's staff for the last period of time that I was in, and that was interesting in its own way, too. So then, following that, we came back to Michigan, and I got a job in the prosecutor's office in Ingham County in Lansing, and Lucille got a job working with the legislature. So that's sort of the early history.
Okay. Let's go back to your Flint days, your childhood days. Did you have any thoughts back then about getting into the law or a career in the law?
Well, I think I might have. I was a good talker. That was sort of the sense of my teachers at any rate. And so I was sort of interested in that way. But, of course, I later came to understand that doesn't have much to do with lawyering. But when I was a child, I sort of thought a little bit along those lines. But I wasn't like a hardcore commit to going into the law. And I sort of concluded while I was at Michigan that maybe that'd be a good thing to do and that I wanted to do that. And so that was how I got into it. But I wasn't really driven to it. I didn't know any lawyers. Our family didn't have any lawyers who were friends. So I didn't know much about the field. But I took a lot of English constitutional history in college, and that was taught by Dr. Leslie, and he emphasized the legal aspects of English constitutional history, and I found that interesting, and so one way or another, law school it was.
Is that what sparked it, that one course? that one professor?
Yeah, I think so. Dr. Leslie was a very talented guy and taught very interestingly about these things and sort of impressed upon his students, I think, at least this student, that the rule of law was terribly important to a society. And so I would say Dr. Leslie had an impact on me.
So you started to think about law school while you were getting your history degree. Was there, when you first started studying history, was there something in particular that sparked your interest in that? Or
well, I have to tell you, isn't very helpful, I suppose, but I found history just really easy. It was a great curriculum for me because I just loved reading this stuff, and it just seemed to me to be pretty easy.
Right.
As opposed to, say, organic chemistry or something like
and
that.
Studying law gets us into the historical
Yeah.
aspects of the law, of course, so
Yeah.
that couldn't have hurt. So was there any delay between your graduation from University of Michigan and law school, or was
No.
it straight on through?
No, straight on through.
Okay. What was you went to George Washington University in Washington D.C., and so here's a Michigan kid, and I would imagine that going to Washington D.C. that was quite an adventure.
Yeah, it was. It was a very big town, of course, and it was a very interesting place to go to law school because the place is sort of alive with the law. I mean, there's the legislature, of course, which is the Congress is there, and it's the focus of things. And Washington, I think probably still today, probably has the most lawyers per capita of any place in the world. So, it was easy to be a law student there. And I managed to get work when I was in law school. I worked for a Republican congressman from Saginaw named James Harvey, a wonderful man. And I worked for him, and I also worked at the Library of Congress. And I might add, in those days, law school was not as expensive as it is now. It was the case that most of the students at George Washington, at least to my understanding of it, worked in the afternoon, and that made it possible for them to pay the tuition and such. Of course, it's now become outrageously expensive at every law school, and that one included. So it would be a little bit hard to do that today, but you could actually go to Washington. It was a big town. There were a lot of jobs in sort of law related in one way or another, and you could make enough money to go to law school.
Well, I think you mentioned earlier that there was one particular classmate that got your attention.
Yes.
And your wife Lucille, who is an outstanding and accomplished attorney in her own right,
Yes, she is.
was, I believe, counsel for the governor of Michigan and has done teaching at Ave Maria Law School and what have you. That's quite a partnership going all the way back to those law school days.
It was very, when we moved to Lansing, the newspaper there, the Lansing State Journal, did a feature, sort of like a two-headed cow or something, about two lawyers married to each other. It was so odd and unusual in those days, it was felt to be worthy of the story.
What do you remember about the law school days?
Well, I remember being poor. That was certainly one part of it. And I also remembered that it was a wholly different environment than undergraduate school had been. It was much more competitive. Law school in those days, and I think it's less so now, it was less collegial than undergraduate school had been. For example, in the time that I was in school, all the men in school, which was most, I think there were 15 or 20 women out of 1,500 students at the law school. Most of the men wore ties. And a lot of that was because they had jobs after school that would require a tie. But it was a much more sort of focused environment than undergraduate school had been.
Was there a law school class or professor who made a special impact on you that when you look back may have kind of shaped some of your interests when you got into the practice of law or the way you thought about the law?
Yeah, there was a guy named Max Eisenberg who taught constitutional law there. Lucille and I both had the same person. She didn't think as much of him as I did, but I really thought the guy was very brilliant. He had been a clerk for Hugo Black on the Supreme Court, the U.S. Supreme Court, and was a brilliant man. He was first in his class at Harvard undergrad and first in his class at the Harvard Law School. He had a distinguished career with the Atomic Energy Commission as a lawyer, and had gone into teaching. He was sort of an abrasive guy and didn't tolerate fools at all well. And that sort of offended a lot of people. I sort of thought it was funny. But in any event, he was my first experience with a textualist. He believed that you look at the words and you try to reconstruct what the words meant at the time they were used, and that is the version of the law that you follow. This has become much more a focus of the law in the last 40 or 50 years. The primary exponent of this, of course, has been the late Justice Scalia, who was a wonderful advocate of this, and I became a firm believer in this. But I think my first exposure to this kind of thinking was Max Eisenberg.
And as you said, that textualist approach wasn't really the legal climate back then. We're talking about the mid to late 60s.
Interestingly, having spent a lot of time thinking about this, because I taught a course in it for 10 years at the law school in Florida, it was the dominant way of thinking about how courts functioned right up until the Warren Court. Lawrence Silberman, a distinguished federal judge, was speaking at an event one time when I was there, and I was at the event, and he was speaking about how there wasn't a Federalist Society, which is sort of the place where the textualists all gather. There wasn't a Federalist Society at the Harvard Law School because one wasn't needed. Everybody was a textualist. And I think that really was true. And it was in the Warren Court period that the notion of what we call now the living Constitution or the evolving Constitution became popular. I think it's very popular now. I'm not much of a fan of it, to be honest. I think it's really a usurpation of legislative power by courts to do this. They're effectively reading statutes to change them by purporting to believe that the words have grown or that the notions in the instrument have grown. And I just don't think that's the case and never have. And that's been a source of some controversy in my life because I served in a judicial capacity with many people who didn't believe that, who really thought that it was up to judges to sort of morph these statutes or morph these constitutional provisions to get them to be what people like today. And that really is the whole antithesis of a written instrument, if you think about it. I mean, it's not just in the law that you see this. You can see this in any kind of written work. I mean, when you read Shakespeare, you need to know what people meant by given words in the time he lived. And when you read the Bible or any other serious tract like that, the question isn't what you think the word should mean. The question is, what did they think the word meant?
The originalist.
Yeah, the originalists. And so I think this just isn't a program that applies to the law, an approach to thinking that applies to the law. It applies to all sorts of documents, every document, really.
Well, and that's something I'll certainly want to revisit later because I'll be curious to know how you envisioned yourself before you got on the appellate bench. But it sounds like the seeds were sown back in that law school class for this outlook on the law and how
it seems sort of dramatic, but I suppose that's more or less true. I mean, my first 20 years in the law, I was a working lawyer. I was a young prosecutor at first, and then I went with a law firm in Lansing that I enjoyed a great deal with Jim Timmer and George Denfield, who were wonderful lawyers, and there were the three of us. And so I was doing the daily work of the law. I was a tort lawyer. I did insurance defense work, so I didn't have much time or occasion to philosophize about what the law to be. I was trying to figure out what this judge would buy.
It sounds familiar. That sounds a lot like my practice, my practice days. If somebody were to look at your resume and trace all of this, trace your history, they would see University of Michigan undergraduate, George Washington Law, and then they would expect right after that big Washington, D.C. law firm or big Detroit law firm, big money. But that's not where you went after graduation from law school?
Well, when we left, we were in Norfolk for the Navy, and when we left there, we came back and settled in Lansing because Lucille wanted to do legislative work, and that is where she ended up, and she had a very distinguished career with the legislature before she was Governor Engler's lawyer for the whole period of his term. So that was where we ended up, and I wanted to do trial work. And the best place to do trial work is, of course, in the prosecutor's office. And so that's what we did, and we had a wonderful life. We really enjoyed ourselves.
Did you use your legal education at all in your Navy service, or were the two completely
Believe me,
separate?
the last thing the Navy needed in 1968 were lawyers. They were trying to put a fleet out there, and so I was legal officer on the ship I was on, but you know that old joke about military justice is to justice what martial music is to music, and it's not much like being a real lawyer.
So this was true naval service. This wasn't a JAG Corps type of
Oh, no.
situation
I
at
was
all.
an
You
officer
were-
on a destroyer. I was
Okay.
communications officer and top secret officer, and the guy who broke the codes and so on, which was always interesting because if you lost one of these things, you absolutely would go to jail. I mean, the Navy was absolutely not kidding about losing their encryption devices. And I used to have to leave the ship and go get the new code books in Europe when we were in the Mediterranean or in the North Atlantic. And getting there and back always amused me because there would be nothing that would be more distinctive, really, in these towns than a guy in a Navy officer's uniform with a pistol, a big white pistol, a belt, and so on. And I used to always say to the captain of our ship, I mean, if I were looking to steal the code books, I'd look for somebody that looks just like that. But there were never any incidents, and we got along fine.
Did any of your experiences in the Navy enter into any of your thinking or shape your approach to the practice of law or later to
Well,
judging?
I don't know. I mean, I think the Navy was a good experience because it teaches you a lot about getting along with people who aren't like you. I had a division of 40 enlisted men who were drawn from across America. They were high school graduates, no college graduates, and they did technical work on the ship. And they had all the problems that very young men have. They were usually 18 to 25, something like that. And they were nice kids. I learned a lot, I think, about how to deal with people through that experience. I learned, in some sense, what it was to lead a very demanding life. I mean, we were out at sea a lot. You'd have 4 hours on the bridge, and then you'd have 8 hours off. And during that, that would go along day after day after day, and you'd have to get your sleep and eat and all that kind of stuff done in that time. So it teaches you something about organization.
Now, our focus here, our primary focus, of course, is your service on the Michigan Supreme Court. But I think we'd be rushing if we were to just pass over your practice days, because you practiced for about 2 decades before becoming an appellate judge.
Yeah.
And I would imagine that of course shaped the way you thought about cases when it came time to be on the bench.
Yeah, it did. We had a small practice. We before the phrase was even known, we had a boutique law firm. We didn't ever think of it that way, but we did pretty good work. I mean, in other words, it was pretty interesting cases, and we were involved in a lot of conflict work for other firms, big firms. So one of the firms I did a lot of conflict work for was Miller Canfield, and I eventually figured out why that was. It was that when big firms send out work, what's the thing they want? They don't want to have the client stolen. Right. So they sent a lot of this work over to me, knowing that we were too busy to steal the client. So I did a lot of that kind of stuff, and we did pretty serious work, and I had a lot of appellate cases in that time. And I became, in that experience, worried about the fact that appellate courts in Michigan were not adhering to a textualist approach to the law. They were treating it as a living, breathing document and making it read the way they wanted it to read. And in doing this, I could never quite agree that they had authority to do it. And I don't think they had authority. They just could do it because they're the last to speak. And so this bothered me, and I became involved in reading about this and thinking about it. And so when I went on the appellate bench, I had very firm views on what I thought the court ought to do and the kind of way we ought to handle cases. And it was not in any sense to benefit some interest or block. It was to make the law work the way the law is supposed to adhere to the principles of interpretation and construction of statutes that are timeless and have been the basis of sound jurisprudence in England and the United States for centuries. And we were drifting away from that, and in my own little way, I wanted to move us back to where we ought to be.
And so that, that feeling was starting to emerge in your practice days. Do you recall a moment in time when you said, I've got to throw my hat in the ring, I want to be on the appellate bench?
Well, not quite that way. I never ran for the court. I was appointed by Governor Engler. And Governor Engler was a very good friend of mine and had been for years. And when he ran for governor, I ran for attorney general. This was sort of a thankless task because I was running against the amazingly popular Frank Kelly. And so Attorney General Kelly won. And I always thought the Republicans had something to say for themselves in the kinds of distinguished people they ran against Frank Kelly. They ran Honigman, they ran Lindemer, they ran Brooks Patterson, and John Smetanka. These were all fine lawyers who ran, and I was sort of pleased to be integrated into that tradition, but I never thought I was going to be Attorney General, and I wasn't. And so anyway, in 1990, when John was elected, that was when I began to think about the fact that perhaps if an appointment came up in the Court of Appeals, I'd apply for it. And one did when Bob Danhoff, the then Chief Judge of the Court of Appeals, decided to retire. And so I applied for that post and received the appointment. And I was very grateful to Governor Engler for that and continue to be grateful to him. He's a fine man and I think really was a great governor in this state. But in any event, so that was how I got on the bench. And then I had to run to hold the seat. And I don't know if I ran a good campaign. I just think nobody noticed. And you had an incumbent designation that said underneath your name, Judge of the Court of Appeals, and that's of course a big leg up. And I won in the '92 election, I guess it was. Yeah, I think that was how it worked. And so I served there until '97, when John appointed me to the Supreme Court when Dorothy Comstock Riley retired for health reasons. So
you're interested in being a judge, but by necessity, you're kind of thrown into the political world.
Yeah.
How did that feel?
Well, I actually sort of liked it. I mean, I'm a gregarious, outgoing person, and I didn't mind the hurdy-gurdy of politics very much. And you're always sort of treated like a flamingo in a barnyard when you're a judge. I mean, if you go to events, they don't treat you like the guys who are running for the Board of Commissioners or something. They sort of act like you have good grammar and so on. Would be offended by being put at the wrong table and so on. So you're always treated pretty nicely. And so I was okay with that, and I enjoyed that part of it. I mean, some of it's pretty arduous, especially when you're running statewide. I mean, that can be quite an amazing experience because the distances are so great. I remember talking to Brooks about what it was like to run for statewide office. He said, here's my memory of running for statewide office. You're looking at the hood of your car a lot, you know. Right. And that is true, you know.
And so you did a lot of travel, then saw a lot of Michigan, the great state of Michigan.
Yeah. The '98 campaign was really quite interesting because Bob Young and Steve Markman were running alongside of me. I mean, the three of us were running, and they are great friends of mine. And we had a single car, and we had some poor soul who was the driver, and we would go around to these various events, mostly Republican-oriented events, Lincoln Day dinners and the like, but a lot of fundraising events too. And we had a great time. I mean, they are wonderful guys, and they're easy to be with. And so that campaign was very arduous and very demanding. The Democrats put up very strong candidates for these things, or at least I don't know how strong they were, but they were well funded. I guess maybe that would be the way to say it. And so it was arduous, but we got through it.
When you got onto the Michigan Court of Appeals, did it turn out to be what you expected it to be?
Well, yes, it was a serious court, and people were very disciplined and interested in doing a good job. I think there was a little surprise that I wanted to change the way people thought about their job. And so that made a few waves. But shortly after I was appointed, the governor appointed later Justice Corrigan, Maura Corrigan, and Markman and Young and other judicial conservatives, I guess for shorthanding what a textualist is, to the bench. And so there were a cadre of us who wanted to do this, and this was dislocating to the people who had been running the show up to that point. Mm-hmm. And so, we had our innings, all very polite and very diplomatic, writing torrid dissents and so on. But I mean, we did try to change the court, and I think we were pretty successful at getting the court, to some degree, refocused on what its proper role is.
Was the day-to-day work what you'd expected? I think, it's kind of a mystery to the advocates. What are the inner workings of the court, and what's the day-to-day like for an appellate judge?
Well, of course, this information is pretty old now. It's back in the early 90s. But the first thing I was struck with when I went on the Court of Appeals was how big the files were. I mean, I'd had a pretty active law practice. I thought I knew what it was to have a big, complicated file. But these things would come in, they'd roll them in wheelies. They'd sort of drop them and they'd tower, they'd sort of shake like a tower of jello. And so just plowing through this, and every month you'd hear, in those days, I think it was 42 cases. So it was just a lot to get through. And we had a very strong, capable central staff at the Court of Appeals who would summarize the briefs and summarize the various arguments, and would have suggestions as to disposition, but they were very deferential and not trying to force that upon you. So it was doable, but you had to keep your shoulder to the wheel. But
it was agreeable, I assume, because your interest in the Michigan Supreme Court, that would just take it up a notch, I would assume.
I occasionally I thought it would be nice to be on the Supreme Court, but something has to happen to make that happen. It was then the court hadn't had much turnover in personnel for a while. And, so I thought about being on the Supreme Court, but I never really knew that it would happen. And then, unfortunately, Dorothy Riley became ill and had to leave the court. And she was a lovely person, a really fine judge. And so I applied for her position and was successful.
What was that process like? You'd already done it for the Court of Appeals.
Yeah.
And so did it feel like just more of the same, or was there a different feeling when it was for the Supreme Court?
I think it differs with everyone's experience. I had been close to the governor who was going to be making the appointment. And my work on the Court of Appeals had been recognized in conservative circles. People thought that I was doing an okay job. I think the combination of these things sort of kept the competition down. And as I recollect it, I may be wrong on this, but I think I'm right. I don't think there was really any serious contender other than me at that time. There were some nominal people who put their names in, but I don't think they had any expectation that they were going to get the appointment. So it was a great honor to get it. I was pleased to get it, and I was anxious to get on with the work on the court.
I did a little bit of research before today, just trying to do my due diligence, and the Supreme Court Historical Society has some wonderful materials, of course, and I bumped into a transcript of your swearing-in ceremony from September 1997. And as I was reading through it, I felt like I was in the room. There was such a warmth with the remarks that the various people made. What do you remember about that day?
Well, it was a big day, and it was in the old Supreme Court chambers in the Capitol, which is a room where the Appropriations Committee meets now, I think, and then too. It's kind of like organizing a party. I mean, you know, you've got this reception afterwards, and you've got friends in from out of town, you've got family in. So you're sort of worried about all of that, and then you've got to make these remarks, and you have to think about that, of course. And my two very good friends in politics have been John Engler and Spencer Abraham, and Spencer was at that point in the U.S. Senate, and so Spencer spoke, and John Engler spoke, and Morrow spoke, I think, as I recollect
So,
it.
yes. Yes.
And so it was a lovely day. I really enjoyed it.
Once you got onto the Supreme Court, what was the experience like? Was it
Well, it was very warm. People were very collegial. Patty Boyle was on the court at that point and was a very fine judge, and she was very warm and welcoming. Conrad Mallett was the chief,
right.
and was very nice and very helpful in every respect. I had no complaints about how I was welcomed or anything. It had been so long since a judge had come on that court that nobody thought to order stationery for me. So when I got there, there was nothing that I could use to send out mail or anything like that. And so, you know, a few little small glitches like that, but it was a good experience, and everybody was fine.
Was the decision-making process at the Supreme Court in any way notably different than what you'd experienced on the Court of Appeals?
Yeah, very different. On the Court of Appeals, the three-judge panel, in my experience, never, ever conferenced before the case to talk about the case. In other words, you'd have the briefs, and you'd read them, and you'd make your notes, and so forth, and you'd be ready for the oral argument. The other two judges would be the same thing. And then you'd conference after the case was argued. In fact, after each day you'd do it. So you'd have maybe 10 or 12 cases. You'd go back into conference and you'd vote on how you wanted them to go. If you were in the majority, you might be the authoring judge, or if not, you might be the dissenter. But it was very, very different than the Supreme Court, because in the Supreme Court, you sit in the conference room, as you do in the bench, based on seniority. So the least senior judge leads the discussion on the case by indicating what he thinks about how he's planning to vote. So I'd be the first person to speak. And I enjoyed that role, actually, because it helped people who were wavering, maybe. And so, you know, you would give your reasons for what why you were going to do something. I was always flattered when my first cases up there, Jim Brickley was serving, and after he was going to, I gave my opinion on the case and why, and went around the table. We eventually got to Brickley. He said, "I want to do what Cliff said." So I was pleased by that. And so then, you know, you do all the cases up there, and Then the method by which it was determined who was going to write the opinions was an age-old thing. They had this is really the truth, they had a box, like a cigar box, and it had it had balls with numbers, like 1, 2, 3, and they would come and they would ask you as the newest justice to pull one of the balls out. And so let's say you pulled out the ball that said 2. If you were in the majority on the second case that had been argued, you'd write the majority opinion on that. The idea was to randomize who was writing, and noteworthily, this is different than the U.S. Supreme Court does it, where the Chief Justice picks out people and has them write it. And that's why you see so many cases in the United States Supreme Court where a given justice will write always on antitrust, or he'll write always on sexual cases. That was Anthony Kennedy that did a lot of that. That would be because the chief would pick. That wouldn't happen on our court because it would be the case you drew out of the ball. So anyway, it would work like that, and you would then, if you'd drawn the case to write, you would write it for, you had about 4 or 5 weeks to get your opinion out, and then you'd send it out to the court, and if it got enough votes, somebody'd have to, who wasn't voting for it, would have to then sign up to write a dissent. And so that would come in, and then the authoring majority would respond to the dissent would respond to the majority, and back and forth it would go. And on the really acrimonious cases, really hard cases, it'd go on a long time.
I find it fascinating that they give the new guy the first word during those conferences. Did you ever feel almost like an advocate? I want to persuade them that my analysis is correct and sound.
I thought they needed persuading.
Right.
So I would be very, very focused on making an argument that would appeal to them, and hopefully pick up the votes we needed for our position.
Did you notice a difference in the level of advocacy between the Court of Appeals cases and the Supreme Court cases? The quality of the briefing, the quality of the oral argument?
Not much. I really have to tell you that it was rare to get great oral argument in either court. I think so often lawyers, very capable, talented lawyers, don't think about what they ought to say to a court. And they're so enmeshed in the case and so enveloped by it that they become myopic as to what they're up to. I remember one case, I don't remember if this was on the Court of Appeals or on the Supreme Court, but it was a case where a corporate treasurer had done something that compromised the interests of the company, and the company was challenging the agreement that he had made. And the law was very clear that if a corporate officer with authority makes a deal like this, that's it. So this lawyer is there arguing it, and I just couldn't stand it. I said to him, listen, you want us to rule that this rule doesn't apply. And what do we do with the next 10,000 cases? I mean, that's what you ought to be telling me. I mean, I realize that you're unhappy with what the corporate treasurer did, but you've got to give us a route. That's your job, is to give us a route that gets to the conclusion you want, that isn't going to destroy the corpus of the law. And until you do that, you're going to lose.
So the Supreme Court advocates tended to be stuck in my client wins, my client wins, my client wins, without the big picture implications for the state.
Yes. Yeah. And another thing that I always found interesting is that the court takes a very few number of the cases that are appealed up to it, because they have the discretion to take the cases they want. And I always used to think, I wonder if anybody on this case ever stopped to ask, why would they take this case? Because they would argue it just the way they'd argued it in the circuit court in Ishpeming. I mean, why would we take that case and not take, we took something like 2 or 3% of the cases that were, well, why did they take it? I mean, I don't think that question ever got asked. So you'd have people stand up and start to talk elaborately about the facts of their case. We didn't take them for the facts. We took it because we thought the law was screwed up, almost always. Or there was some conflict in the law, or there was something very big, not factually, but very big in the development of the law that was going on in this case. And it was not unusual at all that the lawyers would not understand that.
Well, I've seen a number of Michigan Supreme Court justices speak about how the court doesn't view itself as an quote-unquote error-correcting
Yes.
court, that there's something more happening there. And I wonder, now attorneys nowadays have a better shot at getting their day in the Michigan Supreme Court with the mini oral argument process. Has that changed the court in any way, in your view? Has the court become more error correcting through that mechanism, or changed in any other way?
Well, I was sort of the father of the mini oral argument approach, and a little history on this might help. The way the court functions is that if a case is appealed up to the court, so it's there on application for leave, there's a conference of the court on this. Everybody's read this stuff through. And if 5 people want to peremptorily reverse the Court of Appeals on this case, they can do so. And they can do so without oral argument. Now, what if you have a situation where you only have 4, but the 4 think they don't want to waste their precious oral argument time on a case like this? The problem we were having was we had a justice who, for perverse reasons, as I felt about it, would not sign as the 5th person, even though in agreement with the approach. And so what was happening was we were having our oral argument days be taken up with de minimis cases. For example, a person pleads guilty in the circuit court to a crime, and as you know, there are sub-zillion things that the trial judge has to do. You know, did you know you have a right to cross-examine? You know, on and on. And for some reason, the judge misses 5 of the questions, let's say. Well, that's going to be reversible error. We shouldn't have to have oral argument on a case like that. And so I was frustrated by this, and so I thought about this mini oral argument approach, which was to say to the lawyers, we're going to decide, we're going to give you a chance to submit a brief on this, and don't make it the same old brief. I mean, there's something going on here. And then we'll bring you up, we'll give you a shortened time to argue this. This may sound too tedious, but one of the problems with oral argument in the Michigan Supreme Court was, and maybe still is, we gave a half an hour to each side. Believe me, most cases don't need a half an hour to each side. Sixth Circuit gives them 15 minutes. Right. The U.S. Supreme Court, I think, gives them a half an hour. Most federal court of appeals don't give them that kind of time.
If you get oral argument at all.
If you can get oral argument at all. Yeah. And certainly most state Supreme Courts don't do that. So I thought we ought to shorten the time for oral argument, but the hue and cry that went up when that was proposed was deafening. So I thought, well, okay, what we'll do is we'll set up this mini oral argument thing and have a very shortened argument period, and nobody can complain about that. It isn't, you know, that the ghost of Cooley will haunt you, and so so we did that, and to my great surprise, we really started to move a lot of cases, and it is now, I guess, the most used procedure in the Supreme Court for getting cases through the system. Another thing this did was it was much cheaper for litigants. It costs an awful lot to have somebody write a brief after leave is granted that's the full-blown, 40-page brief with appendixes and whatever, and then have the big oral argument and so on. So it worked out to the benefit of the litigants, and it worked out to the benefit of the court. And I think that's why it's so popular.
When you look back over your Supreme Court days, are there any opinions that you authored that you're particularly proud of?
Well, it wasn't a big case. I wrote a case called Wilkie versus Auto Owners. And it was a case which was about the construction of an insurance contract and whether or not, if the terms were harsh, you still had to comply with them. And the lower courts had gotten the vapors and couldn't do it. And so I led the charge on our court to write an opinion that said, we will enforce contracts in Michigan. We are not going to find ways to evade them. And while there are times, adhesive contracts or unconscionability, these should be defined narrowly and sensibly. It is not a good enough reason that the judge doesn't like the contract. And this wasn't one of my cases, but it was a case in Louisiana that I always thought was illustrative of this. Most big-time franchise corporations, McDonald's, Kentucky Fried Chicken, and so on, have very punitive contracts with their franchisees. So, for example, if on 3 random inspections they find the restrooms dirty, you lose your franchise. And what does that do? That means everybody's pretty careful about their bathrooms. So is that fair? I mean, people who don't know anything about the franchise business think, gee, that's really, this guy's got this big store, he spent all this money, you're going to pull the franchise. Well, it was important enough to the people entering into this contract that they agreed to it. And some courts enforced those and some courts didn't. But the truth of the matter is, most contract provisions, if you really understand the case and really understand what was going on between the parties, they do make sense. So it is very important to an outfit like a McDonald's or a Wendy's that a store that doesn't get repeat traffic, say a store on a turnpike or something, be just as clean as the one that gets lots of return traffic that can see a reason to keep their store clean, whereas the one on the turnpike might not see it. They need to be able to have that kind of control over franchisees to keep the franchise, to keep the stores as they should be, and to thus keep the company strong. But if you don't have a background or a knowledge of that, you'd be inclined to say, well, that's really pretty rugged. I think I'm going to blow a hole in that provision and say, it's got to be a reasonable thing, put in all these lawyer weasel words. And so anyway, I got us started, I think, thinking about contracts in a different way and enforcing contracts. And this makes it better and easier for people to do business where they aren't, angling on the fact that they'll get some judge who will rewrite the contract. So this case was a small case, but it established this precedent. And as a matter of fact, that case, Wilkie versus Auto Owners, was the basis of the case you were asking me before when we were off camera. After I left the bench, I along with Larry Saylor, wrote briefs in a case that got the award for best brief or something. And that was in vindication of Wilkie. The lower court had refused to enforce Wilkie, so they came to us after the lower court. And I suggested, look, this is what you ought to do. Just go up there and tell them that this is a Wilkie case, and you ought to reverse this. Well, that's what the court did. And so anyway, the idea was to establish sound principles for contract law. And I was active in that area, and I was active in the area of workers' comp. Workers' comp had been a hodgepodge because judges weren't willing to enforce the statute as written, and I felt that we should, and that if we did this, the legislature could correct it if they didn't like what we were doing, and the litigants would know. It wouldn't be a mystery when you started one of these lawsuits as to how it was going to come out. The result of this approach, and I wasn't the only one doing this, I don't mean to suggest that, but the result of this approach was to dramatically reduce the amount of appellate litigation in Michigan, because people who could read and were willing to understand what the document said would know how the case was going to end up. It wasn't a complete crapshoot when you got it into court. So the Court of Appeals dropped from 13,000 cases to 2,800 or something like. I mean, the figure's a little muddled, but that's more or less right. And the same thing happened up the line at the Supreme Court.
And that's when I think about your time on the bench. A lot of people credit Justice Scalia for this move toward textualism. But it seemed to me, and I was a Michigan practitioner, but it seemed to me in Michigan and in other states, to the extent that I was aware, that there was a bit of a wave of restoring primacy to the words, whether it be the words in the contract, the words in the statute. Did you, and it sounds to me like you had a good sense of that, that you were actually trying to spearhead that and to move both the Court of Appeals and the Supreme Court in that direction.
Yes.
Did you succeed? Do you feel like, are you satisfied with your
Well,
with the results?
Well, I was satisfied that we were moving the ball in the right direction, and that this was the appropriate way to do things, and this is how American courts should function. You know, times change, people leave benches, other people come on. The profession is full of living constitutionalists. I mean, the number of people who understand what I'm talking to you about are very small in the profession. And it's many times vulgarized by saying we're pro-insurance company or we're pro-employer. I mean, this isn't it at all. We're just enforcing the statute law that pertain to this area, or enforcing the contract, or enforcing the Constitution, giving it its natural and reasonable reading. So the law schools, and having been a professor in one after I left the bench, I know this to be the case. The law schools are full of professors teaching the living Constitution. And this is sort of like investigative journalism. You know, you aren't telling the story anymore, you're trying to make the story end the way you want it to. And there are a lot more lawyers like that applying for judgeships than there are lawyers like, say, a Brian Zara, or a Steve Markman, or a Bob Young, or a Maura Corrigan, who are believers in traditional approaches to interpreting constitutions and contracts. And Scalia was instrumental in this. Another great thinker on this was Lino Graglia, professor at the University of Texas, who wrote wonderful things on this. And Graglia used to write very convincingly about the fact that what we are doing effectively with this living Constitution stuff is we are moving away from a government where the people govern through their legislature and moving to a government where lawyers, in the guise of being judges, are legislating. And that is a very profoundly anti-democratic direction. So, to be understood in way more simple terms, when the court puts something in the constitutional deep freeze, let's say same-sex marriage, when the court decides that it's going to recognize same-sex marriage as a constitutional right, notwithstanding that it's not in the Constitution, but has simply been sort of created by judicial thinkers, you really have taken away from the people their ability to decide on this question. Do we want to have same-sex marriage, or do we not want to have same-sex marriage? That was, up until that time, how that question was always decided. Judges had no role in that. But when you constitutionalize something, such as we did with abortion, same-sex marriage, and lots of other things, you really take the people out of the equation, and it's a totally black robe operation from that point on. And nobody ever thinks about the fact that judges don't have any better credentials for doing this than common men do. Scalia used to say, I don't know a thing about abortion. There's nothing in the law, there's nothing at the Harvard Law School that teaches you anything about abortion. And yet I'm one of 9 people who will decide this question. And I think he was right in that regard, that this, like so many other things, can be left to the legislative process. And that was the animating principle of the Constitution. This was the first time in the history of the world where regular people would be able to govern.
How do you attack a case like that?
Well, common law is a bit of an exception to what I've been talking about here, because common law is court-made law. So courts are able to change it should they wish to, until such time as the legislature enters the field and enacts a statute in the area. So, first-degree murder, to just take an easy case, first-degree murder is a common law crime. And the legislatures in most all the jurisdictions in the United States and in the English-speaking world have all codified it. So had they not codified it, judges could change the rules in first-degree murder, and occasionally did. But now they're not able to. So there are, now in the area of property law and torts, it's mostly all common law. So judges have great power to do that until, again, the real authority steps in, and that is the people through their legislature. And then it's hands off, unless it's unconstitutional, which it rarely is.
Did that pose a special challenge for you? It feels the common law is sort of untethered in a way. I mean, it's a...
No, I didn't feel so untethered. I had no trouble with that. I was perfectly willing to follow the common law, and had no trouble with that. We had very few common law cases, though, really. Most of our cases were the construction of written instruments, statutes, constitutions, whatever.
Now, I asked you if you had a particular opinion that you were proud of, but of course, when you're on the Supreme Court, you're voting on every case.
Yeah.
Some years have passed, and when you think back to your days on the Supreme Court, are there certain cases that just jump to mind?
Yeah, I think one is a decision by later Chief Justice Young, Hathcock versus Wayne County, which undid the Pulltown case, which was a very bad decision, sort of a result-driven decision in the 80s by the then Supreme Court. There was that one. There was the clarification of the workers' compensation statute, a bunch of those cases. There was also a case I wrote that was very unpopular, but it was on no fault. I'll be damned if I can remember the name of it right now, but it was a
Krynick case? Krynick, was it?
I don't know,
case.
maybe that's right.
Okay.
But it was a case where I went back and looked at the No Fault Act and sort of cleared away the chaff and said, this is what it says. Now, this did not meet with much welcoming arms, much by way of welcoming arms in the plaintiff's bar, because they had managed to get constructions of the statute that were very favorable to them, and this was not. But it was not because of any animus against them, just simply because this is what the statute said. But those decisions, I thought, were extremely important and very useful in establishing what the court was supposed to be doing. We were not politicians in black robes. We were judges.
This may seem like an odd question, but you're working day in and day out, wherever it is. And for you, it was the Supreme Court for many years. What was the most fun part of the job? Was there anything about the job that was just particularly satisfying?
I think the most fun part of the job was getting the right answer. You know, it was sort of like playing charades or something, you know, where person is saying, they're acting like they're singing and you say, aha, it's Stranger in the Night, you know, Strangers in the Night, whatever. And it's sort of a similar reaction when you're reading a case through and the lower courts have just missed analyzing it correctly, and you're able to do it. I mean, you can say, oh, that's the rule. That's why that's what we ought to be doing. That was lots of fun. And my great friend on the court was Bob Young, brilliant lawyer. I mean, really a smart guy. And we would spend a lot of time every day sort of bouncing back and forth cases that we were deciding, trying to come up with the right answer. And when you got it, you really felt good. It was, you know, sort of like getting a horseshoe or something. You know, you were right on target.
How did things change when you became the Chief Justice? The Chief Justice, of course, very prestigious. You were Chief Justice for 4 years, I believe.
Yes.
05 through 08. It sounds like a bunch of extra work. It's very prestigious, but there's a lot of extra work with that, isn't there?
Less than you'd think, really. We had a very strong staff. I mean, Corbin Davis, who was the clerk when I was there, was a very old friend of mine. He used to come up, he'd say, you know, this place would work just fine if you people would quit screwing around with it, you know. And there was a lot of truth to that. Anyway, the duties of the chief were very much less than people, I think, would think they were. you had some ceremonial things. You'd be the guy who would start the sessions in court off and that sort of thing. And you'd also be the sort of public face of the court. You'd do presentations before the legislature and so on. And I found those pretty effortless. I didn't have a lot of trouble doing that. And I enjoyed the job. I enjoyed being able to present some of what I've been talking to you about this morning to school groups and to larger crowds about what they ought to expect from a court and what they shouldn't expect from a court. And some of these things were controversial because the power of the people who want the court to be in the business of moving the law, that's a very persuasive bloc, and there are a lot of them.
But it sounds like there's an element of community outreach with the Chief Justice. I seem to recall Chief Justice Young mentioning somewhere along the line about traveling around the state a bit. Did you do any of that?
Oh, yeah.
Okay. Remind you of your campaign days?
Yeah, a little bit less stressful, but everybody when they opened a new courthouse wanted to have you. And then, of course, if you consented, then you'd have to sit around and think, what am I going to say to these people? I mean, it's a building.
Well, you mentioned earlier, and I was going to sing your appellate brief writing praises by remembering for the audience that after you were done with your Supreme Court days, you became an appellate advocate. And you've been doing that for some time now, and at a high level. You were indeed a co-author of a brief that won the Thomas Cooley Law Review's Distinguished Brief Award. Mm-hmm. So is that an unfair advantage, having been on the appellate bench for so long, and now you know, does it give you a special insight to how to reach the mind of an appellate judge?
Yeah, I think it does. The court that when I left the court, I began to practice with Miller Cantfield, a large Detroit firm, a wonderful firm. I must say I've been terribly happy there. They treated me wonderfully. It's a great firm. And I began to sort of help us with our appellate arguments. And I used to tell these brilliant young lawyers who were really doing most of the writing, look, these people, this is a court that's a majority of textualists. So don't put in all the wonderful ideas you have about how the law should read. Just look at it and figure out a way, using a textualist format, that our client can win. And so that was very helpful to them. And then they began to do this, and they began to appreciate it. And we had pretty good luck. You didn't win them all, but we had pretty good luck. But a lot of that was because the luck we had was because I knew what the court would be looking for. So to go back to the example I used of the corporate treasurer, we would not be arguing, gosh, this is a terrible, rotten thing this guy did. How can we help you without wrecking the law? That's what you want to tell this judge. I mean, everybody must know that this guy compromised a claim that was worth $1 million for $10. And that should make everybody at the corporation very unhappy. But now what can they do? Is there anything they can do? Because he had the authority to do this. And you've got to come up with a theory as to how that court can help you. And that's a thing I think a lot of lawyers don't do. And they'll say, they sort of have a feeling, hey, that's your job. I've told you this atrocity that happened. Go figure out a way that the good guys can win. Well, maybe the judge can figure it out, maybe he can't, but it's a lot better if you figure it out for him.
When I look back over my career, I've been spoiled rotten with wonderful mentors. And you mentioned your influential constitutional law professor in law school, but in your practice days or in your judging days, have there been any special mentors or sources of inspiration and strength for you?
Well, when I practiced law, my partner Jim Timmer was a brilliant, brilliant lawyer. This guy, very interesting man. At 17, he was in the Battle of the Bulge in Germany, and he and his twin brothers both were. He and his twin brother were both in the Battle of the Bulge. Uninjured, fact, this is really off point, but very interesting. They had 5, it was a big family from Grand Rapids, they had 5 boys in the service in World War II, and none of them got hurt. Can you imagine that? They were all in frontline duty. In any event, Jim then came back to Michigan and went to school at Calvin, was a math major, then went to Michigan Law. Brilliant legal diagnostician. I would have a new case come in, and I would walk in. This was almost always in an area of the law that he didn't do anything in. And I'd say, what do you think about this case? And it would just be astounding. He would just know what we ought to argue. I mean, it was something to watch and a great asset to have. Well, he was a great help. And George Dentfield, the other guy that was my partner in those days, was also a fine lawyer and a fine guy. As a judge, I think the most important judge in my career was Scalia. I spent a lot of time reading his stuff, and any law student ought to read Scalia's writing. I mean, he writes like a dream, and so he was important. I think Bob Young and Steve Markman were important, and Mora were important also. But in terms of when I was a guy doing trial work, I always thought Jack Warren in Ingham County was a great circuit judge, and there were others also, but those were the ones that, as I think about it now, were important.
We've been talking about your professional life, but I'm curious, when you're out of work, were there any community activities or organizations that were important to you where you wanted to devote your time?
Well, yeah. I was active in the Michigan Dyslexia Institute. One of our children had some issues along that line, and I became involved and was on the board. Both my sons were in the Boy Scouts, and I was on the Boy Scout Council for the county here. And then I did an awful lot of work in politics, I have to tell you. I mean, I did fundraising for many people in the Ingham County area that were involved with that. And then Lucille and I were very involved in our church. And so those were, I think, were the major areas of my activity.
When you're fundraising for another political candidate, is it easier on the heart than when you're the candidate?
Yeah, you can say blushingly, things that make you blush about yourself, you can say about somebody else without much trouble.
Do you like the way that Michigan selects its judges?
Well, I've had some involvement in that. After I left the bench, Marilyn Kelly, who served with me on the Supreme Court, and Jim Ryan, an old Supreme Court justice from the period in the 80s, began to work on this concept that they cleverly named merit selection. And I saw a lot of problems with merit selection because, first of all, what is merit? I was very involved in that, did a lot of speaking about it, and it was successful, I think. I mean, I was the only one on that side, so I think I was successful in stopping that from becoming law, because I just thought it was a lousy idea. Because merit selection really, at the end of the day, comes down to political selection. And it's flawed. I mean, it sounds great, but it's flawed in its nature. I mean, if you and I were applying for a judicial post together, the fact that you got an A in contracts at Law School 1 and I got a B in contracts at Law School 2, who's the merit selection there if 2, let us say, was a better law school? And the like. I mean, if we're going to say, well, we're going to care about people's community activities, is it going to be disqualifying to be on the wrong side of the abortion question? And, you just can't find merit selectors who are immune from this. So while elections aren't perfect, we have a system in Michigan which I think is pretty darn good, and that is I think it's about 70% of the people on our benches get there by gubernatorial appointment. And as it works out in Michigan, just about always, every 8 years, we flip from Republican to Democrat to Republican, and so on. So you get a smattering of the people that both sides of the aisle would like in their time. And so you get appointments which are meritorious, I think, for the most part. I don't think many of these appointments are solely because of political connections, although there's some role for politics in this, but I think most governors, in my experience, have been pretty interested in finding good lawyers to do this, good lawyers who agree with them on the trajectory of the law that they'd like. So you have most of your people here are appointed, and then after they're appointed, they are almost never opposed unless they do something personally scandalizing or the like. The only place where there's an exception to that is in the Supreme Court, where you always have an opponent and so on. But that's only a small group of judges. It's only 7 out of the system of about 600. So 70% of our judges are appointed. The rest come through election. And I think the system works pretty well. I mean, all human systems have their flaws. This one has its flaws. But by and large, I think it has worked pretty well. I think we have a pretty good judiciary in this state.
Now you're too busy, you've been too busy working and also enjoying life, like your recent trip to Italy that we had a chance to speak to you about before we started, to think about your quote-unquote legacy. But I wonder if I could impose on you. What do you think? What would you like your legacy to be? What do you think your legacy will be?
Well, I don't think I'll have a legacy, number one. But number two, if I did have a legacy, I think it would be that I avidly encouraged the redirection of judicial thinking to go back to first principles. That would be what I would like to be remembered for.
And you actually wrote about this. I was looking at. I saw you speak, and then I saw an article that the speech produced in a law review, and I noticed when you speak of the return to first principles that you quoted favorably to some of Thomas Cooley's writings about constitutional limitations. So in a way, you feel like you've circled Michigan back to what Cooley was writing about back at the court's infancy.
I tried, and Cooley really was a giant. I mean, really remarkable judge. Do you know, when I think it was the 400th anniversary of Harvard, I remember reading this thing in some history book. I thought it was so fascinating. They were looking for a speaker for this, the law school's celebration of this. And they picked Cooley over Holmes. Holmes, of course, was on the faculty, but it was in the 1880s. And they picked Cooley. That's how big this guy was in the world of the law. And I think in this state, people don't quite understand what a titan this guy was. He was really quite remarkable, and really was an important figure in American law.
I actually have a friend who was exposed to some of Thomas Cooley's writings in training to become a police officer on the East Coast.
Really?
Yeah, and when they were learning about constitutional principles.
Isn't that something?
Yeah, so you're talking about his reach. It's a far reach.
That is a big reach.
Yeah, national reach.
Yeah.
Now, maybe to finish off, if somebody's watching this right now who says that this is an interesting career path, this is interesting stuff. I could envision myself or aspire to the bench, to the appellate bench, to the Michigan Supreme Court. What advice might you give?
Learn how to write. Learn how to write. Everything in the law is writing. Everybody thinks it's talking. Even I did, as I told you earlier when I was a kid. It's not talking and speechifying. It is writing. Learn how to write, because if you can write, you can organize and you can think through your ideas correctly. I often think schools advise pre-law people incorrectly. They have a pre-law curriculum and it's Constitution this and whatever. I think they ought to have them take every course where they have to write. I mean, you can pick up this stuff about the Constitution, you can get that in a second course or something. But what you really need is to be able to write.
Well, I teach writing, and so people are probably going to think I bribed you to give that answer. But
the fix is in.
I can't think of a better way to close our discussion this morning. And I want to thank you so much for your time.
Great, thank you.
Great to talk to you again. And
Mark, you did a nice job, and I appreciate it.
Well, I letting you talk was my strategy, and it worked very well. So thanks again,
Thank you.
And all the best to you.
Thank you very much, Mark.